everyone. It is now noon, so we are going to go ahead and get started. Thank you so much for joining PHRC for our Fair Housing and Power Hour series. My name is Brittany Mellinger, and I'm the Fair Housing Training and Outreach Coordinator at PHRC, and I'll be your trainer for today. Just a few notes before we get started. I do want to let you know that that this training is being recorded. We do that so that way this information is available after the fact. Just wanted to let you know that we are recording today. I would like to thank our ASL interpreters as well as our captioner for making this program accessible. I do want to let you know that we will also be sending out the slides from today's presentation as well as materials and links that we discuss. So you will receive all of that information within a few days. And with that said, we are going to go ahead and get started. We do this series because we want to make sure that everyone is fully aware of their right to fair housing in Pennsylvania. Housing is fundamental to well-being, and we believe very firmly that everyone deserves the right to fair, healthy housing that meets their needs, free from discrimination. Our training today is going to be on reasonable accommodations and modifications, and we've got a couple goals for our session this afternoon. So we will be providing a brief introduction to the Pennsylvania Human Relations Commission. If you're not familiar with our work, we are going to do a very brief level setting on fair housing laws, protected classes, and general discriminatory practices before diving into the central topic today, talking about the reasonable accommodation and modification process, discussing some examples of reasonable accommodations and modifications that we see complaints come in on, and sharing an overview of how you can file a complaint if you believe that you've experienced discrimination, as well as answering any fair housing questions that you might have. So we designed these trainings to be interactive. So I encourage you to make active use of the chat. If you haven't already, please feel free to say hello in the chat and introduce yourself. Let us know where you're coming from. And throughout the presentation, I may ask you for feedback, questions, and ideas in the chat as well. To start off with our organizational overview, we are the Pennsylvania Human Relations Commission. We've been around since 1955, and we are the state's leading civil rights enforcement agency, making sure that Pennsylvanians can live, work, and learn free from unlawful discrimination. We have a two-part mission. So we work to enforce Pennsylvania's non-discrimination laws, which include the Pennsylvania Human Relations Act, as well as the Pennsylvania Educational Opportunities Act. And by enforcing these laws, if someone would file a complaint, we would conduct a thorough investigation to see if there is a violation of our laws. But beyond reacting when complaints are being filed, we also proactively work to promote equal opportunity for all in Pennsylvania. We do that through educational programming, trainings and seminars such as this one, as well as in the other areas that we work. We hold events in local communities. You may have seen us as part of the Beloved Community Tour or another in-person event. And we also have a lot of active engagement in local communities through our advisory councils, as well as our social justice ambassadors as well, which are volunteers that help to spread the word about the services that we have to offer and Pennsylvanians' protections against unlawful discrimination, to make sure that everyone is fully aware of those protections and is able to file a complaint if they believe that they've experienced discrimination. So if you're interested in learning more about any of those opportunities, we do have that information on our website as well. We cover the entire state of Pennsylvania, and we do that through 3 regional offices. Our Western region is covered by our Pittsburgh regional office. The Central region, which extends up into the Northeast as well, that's covered by our Harrisburg regional office. And then in the southeastern corner of the state, that is covered by our Philadelphia regional office. I mentioned our two laws, and I want to just provide an overview of what they cover. So the Pennsylvania Human Relations Act really does the heavy lifting. So that covers employment, housing, commercial property, public accommodations such as access to businesses, public services, local government, things like that, as well as primary and secondary education, so up through high school. The Pennsylvania Fair Educational Opportunities Act extends that into higher education, such as colleges, trade schools, technical schools, vocational schools. If you have any further questions about our work as an agency, that was a very brief introduction. You can find lots of great information on our website, or you can reach out and one of our staff members can share more with you. But our focus today is going to be specifically on housing. All right, let's start with our fair housing laws and their goals. So we talk about fair housing as having two goals. The first, ending housing discrimination, making sure that no one is kept out of housing opportunities based on their protected class or their identity. But it goes beyond that. Goal number two is promoting diverse, inclusive communities. And oftentimes we don't pay enough attention to this goal of fair housing. This is called affirmatively furthering fair housing, defined as taking meaningful actions in addition to combating discrimination that overcome patterns of segregation and foster inclusive communities that are free from barriers that restrict access to opportunity based on protected characteristics. So acknowledging that we've got a problematic history with our housing system. So we've had practices and laws and policies that have excluded groups of individuals from quality housing opportunities and investment in communities. So there are significant challenges in making sure that everyone, regardless of their identity, can access quality housing that meets their needs. So there's additional work that needs to be done to make sure that we have welcoming and inclusive communities that are full of opportunities for everyone. So what do our fair housing laws cover? They cover the sale and the rental of housing, as well as housing-related transactions. The sale and the rental of housing is relatively straightforward, right? But housing-related transactions can be a little bit more vague. Housing-related transactions refers to any of the industries that surround housing. So it could be anything from a home appraisal to assess the value of a home, or the ability to get a mortgage, or to get insurance at a fair price. Any of these things can impact a household's ability to access a home. So these are covered under our fair housing laws as well. The types of housing that are covered under our fair housing laws are broad. So it's anything from an apartment to a single family home, manufactured home community, condominiums, public housing, nursing homes, dormitories, and more. Even some types of shelter are covered under our fair housing laws. And I want to discuss two discrimination theories, or two types of discrimination that people experience. The first is disparate treatment. And that's often what we think about when we think about a fair housing issue. So that's treatment that directly discriminates against a member of a protected class. So looking at the protected class of disability, since that's what we're going to be focusing on today, that might be someone with a visible and observable disability coming up to tour a home and being told by a housing provider that the house isn't available because the housing provider does not think that this home will be safe for this individual. So someone that's denied a housing opportunity on the basis of their protected class. Disparate impact, on the other hand, can be a little bit more subtle. So it's a policy that's neutral on its face, doesn't mention any protected class, but it has that disproportionate or disparate impact on members of that protected class. So looking again at individuals with disabilities, say a housing provider would have a policy that would say that everyone, in order to qualify to live there, would need to have full-time employment. Doesn't mention disability, but we know that individuals with disabilities are much less likely to have full-time employment. The employment rates are lower in that group of individuals. So this policy may have a disparate impact against individuals with disabilities. Next, I'd like to share our relevant fair housing laws. We have 3 different levels of fair housing laws. So there's the federal laws, which include the Fair Housing Act of 1968, as well as Section 504 of the Rehabilitation Act of 1973, and the Americans with Disabilities Act of 1990. And those second 2 are specific for individuals with disabilities, providing that disability-related protection. At the state level, as I mentioned earlier, it's the Pennsylvania Human Relations Act that forms the basis of our protections. And there are many different local ordinances as well that provide further protections beyond what's available at the state or the federal level. So at the federal level, it covers 7 protected classes and really forms the basics of the protection. But our state Human Relations Act adds on further protections, which you'll see in the protected classes as I get to that. And different localities often have additional protected classes. So it's important to know if you have a local ordinance and a Human Relations Commission that enforces that ordinance to know if there are additional protections beyond what we'll be covering here today. And if you're in an area where you know that there's a local ordinance, I'd encourage you to put that in the chat and share that. Either the area that you're in or any additional protections that are part of that local ordinance as well. All right, I'd like to touch on housing jurisdiction briefly. So first, we're going to talk about covered providers, so folks that need to comply with our fair housing laws. So under the federal level, with the Fair Housing Act, housing providers with 4 or more properties need to comply with our fair housing laws. Now that's unless they publicly advertise vacancies or receive federal funding. If they do publicly advertise their vacancies or if they receive federal funding for their housing, then they do need to comply, even if they would own fewer properties. Now, under the Pennsylvania Human Relations Act at the state level, it's housing providers who have 1 or more properties. So even if a provider would not be a covered provider at the federal level, they could still have a complaint filed against them at the state level as well. The filing timelines look a little bit different at the federal and the state level as well. So federally, a complaint must be filed within 365 days of the date of the last harm. So within a year, if someone would wish to file with the U.S. Department of Housing and Urban Development. To file under the Pennsylvania Human Relations Act, our filing timeline is a little bit shorter. So complaints must be filed within 180 days of the date of the last harm. So about 6 months if you're filing with the PHRC. Now, our next slide will show our list of protected classes, but I'd love to offer you the opportunity to share any protected classes that you're familiar with in the chat. So I know I've already talked about the protected class of disability, but let's see if we can name the rest of the protected classes as a group. I'd encourage you to go ahead and put that in the chat now. And if you're not sure, please feel free to take a guess. This is a brave learning space, and I encourage you to go ahead and put any ideas that you have in the chat. I will give a brief pause to allow you to do that. All right, I see in the chat we've got national origin, which is absolutely a protected class at the federal and the state level. Religion, absolutely. Familial status, sex, absolutely. Gender is covered under sex and age over 40. Race, absolutely. Union is not considered to be a protected class, but thank you so much for putting that in the chat. So we covered a lot of the main ones, and I'm going to go ahead and show you the slide with the breakdown. So first, we're going to talk about the ones under the Fair Housing Act, which are race, color, national origin, familial status, religion, sex, and disability. So those are the big 7. Under the Pennsylvania Human Relations Act, you can see that that's very closely mirrored. So we've got race, color, national origin, familial status, religious creed, sex, and disability. But we add on age 40 and above. Excuse me. We've got ancestry as well as the use, handling, or training of support animals for disability. So those are the protected classes under the Human Relations Act in housing. We're going to talk about these in a little bit more detail, focusing specifically on 3 separate ones. I see there's a question in the chat, why religious creed versus religion, and that was the language that was used in our act versus the Fair Housing Act. We did just in 2023 provide some regulations that did more clearly define religious creed, and we have those on our website under the policy and law section of the website if you're looking for more information on that. But under familial status, that includes families with children under the age of 18 living with parents or legal custodians. It includes people who are pregnant, as well as people who are securing custody of children under the age of 18, and that does include foster children, not just biological children. Under the protected class of sex, we did pass some regulations, which I just mentioned. They became effective in August of 2023, and that also defines the protected class of sex. And it established that sex may refer to pregnancy status, childbirth status, breastfeeding status, sex assigned at birth, gender identity or expression, affectional or sexual orientation, as well as differences in sex development. And we use these regulations as the Commission accepts complaints, conducts investigations, and adjudicates cases. And you can see there's a link at the bottom of the screen that will take you to more information on that. I wanted to highlight this specifically because you didn't see gender identity, sexual orientation, things like that under the list of protected classes. But I do want to emphasize that we do have these protections under our state regulations. So if someone believes that they've experienced discrimination on this basis, they can file a complaint with our commission and get that investigated under the protected class of sex. I do see there's a question in the chat about the use, handling, or training of support animals for disability. That does include emotional support animals in housing. And we're going to talk about that a little bit further on in the presentation. That's a great question. All right, moving on to the protected class of disability. So this is defined as a physical or mental impairment that substantially limits one or more of a person's major life activities. Some examples of this, and this isn't exhaustive, but some examples include caring for oneself, walking, seeing, hearing, speaking, breathing, learning, or working. So this might be something that's observable when you first meet someone, or it might be something that's non-observable that you wouldn't know until someone makes that reasonable accommodation or modification request. Now, fair housing laws protect those who have a disability, those who have a history of a disability, as well as those who are regarded as having a disability. And I mentioned those second two because they're not quite as obvious, perhaps. But if someone is denied housing opportunities or housing services, treated adversely in their housing based on a housing provider's knowledge of their medical history or perceives them as having a disability and would deny them housing, that would be discriminatory as well. I want to highlight some exemptions briefly. So individuals who are currently using illegal drugs or controlled substances, they would be exempted from disability-related protections. Now, this does not include those who are in active recovery. So if someone previously was using controlled substances, but they are in recovery, they would have disability-related protections. And then individuals who pose a direct threat to the health and safety of others would also be exempt from disability-related protections. Next, I'd like to briefly go through some discriminatory actions. We do have a Fair Housing Fundamentals course that covers these in more details, but just briefly, these would be actions that would be discriminatory if they were taken on the basis of someone's protected class. So discriminatory statements, whether that's put in an advertisement or in a conversation, whether it's an email or a text, discriminatory statements about someone's protected class, or discriminatory inquiries. So asking about someone's protected class when they're inquiring about housing, steering folks to different types of housing, to a different neighborhood, a different area of a complex, a different housing complex on the basis of their protected class would be discriminatory. Refusing to sell, lease, or finance housing, as well as unfair appraisals. So basing the appraisal value of a home on the basis of someone's protected class would be discriminatory. Predatory lending, so offering folks different terms and conditions or services in lending on the basis of their protected class, as well as discriminating in the terms or conditions of their housing. So in rental housing, that could be the terms in the lease or the policies of the housing provider. Unequal provision of services and facilities is considered to be discriminatory when it's on the basis of protected class. And then harassment in housing is discriminatory, whether it's sexual harassment, harassment on the basis of race, religion, disability, whatever the protected class is. So individuals with disabilities have protections against all of these discriminatory acts, but refusal to provide reasonable accommodations and modifications are unique to the protected class of disability in housing. So this is specific to this protected class, and that's where we're going to focus our attention today. So we talk about these protections a lot, and we have a lot of trainings on this because we receive a lot of complaints about this. They made almost half of our fair housing complaints at PHRC last year, more than any other protected class. And that's similar across our other subject areas as well. We do see a lot of complaints on the basis of disability. So as I just mentioned, in addition to all of the protections against the other discriminatory practices, individuals with disabilities may request reasonable accommodations or modifications when they're needed in order to use and enjoy their housing. I want to define the difference between the two types of requests. So a reasonable modification, that's a structural change that's made to the premises, whereas a reasonable accommodation is a change, an exception, or an adjustment to a rule, a policy, a practice, or a service. At this point in the presentation, I'd love to take a quick pause and invite you to share an example of a reasonable modification or accommodation that you're familiar with, something that you've either encountered in your work or your life, or you're familiar with in another capacity. All right, adding a ramp, absolutely. Adding grab bars in the showers or the bathroom. Yeah, that's a really common request. What else? Otherwise, changing a bathroom to meet someone's disability-related needs, absolutely. The height of the toilet, that can be really important for someone to be able to get up and down. A stair chair or a chair lift to get up the stairs, or widening a doorway in order for someone to be able to get through there, particularly if they're using assistive technology, that can be really important. These are all excellent examples of reasonable modifications. So changes to the building, to the structure. I see we've got an example of a reasonable accommodation, which would be changing the due date for rent based on when someone's receiving their disability payments. Absolutely. Elevator access, removing carpet, that can improve accessibility. Adding a sliding glass door instead of having a doorknob that opens out. Changing the room size Could be if you're actually changing the size of the room, that could be a structural modification, or perhaps changing to allow someone to have a different unit size based on their disability-related needs could be an accommodation. And identifying special parking or reserving parking can be a reasonable accommodation request. Excellent job, everyone. Thank you so much for sharing all of those examples. I'm going to go into a little bit more detail on reasonable modifications first. So it is discriminatory to refuse to allow a person with a disability permission to modify and pay for changes that enable them to use a facility. So it's the housing provider's responsibility to grant that permission, and then it's the resident or the tenant's responsibility to pay for the changes. That is, unless the housing provider receives federal funds. If they are federally funded, then it's the housing provider's responsibility to pay for the modification, not the tenant. And a housing provider may require the resident to restore the interior back to the original condition at the end of the tenancy, minus normal wear and tear. So we covered both of these examples in the chat, not allowing someone to install grab bars in the bathroom or allowing a resident in a wheelchair to construct a ramp. Moving on to reasonable accommodations, it is discriminatory to refuse to make reasonable accommodations in the rules, policies, practices, or services that are necessary to afford equal opportunity for a person with a disability to use and enjoy a housing accommodation. So let's see, we covered the first one in the chat as well, not allowing a person with a disability who receives disability income to pay their rent on a different date than other tenants. Not designating reserve parking for an individual with disability who needs it in order to access their housing. And then not allowing a person with a disability to have a service animal or emotional support animal, even if there's a no pet policy at that housing complex. But sometimes reasonable accommodation requests are not just for housing providers. Sometimes local governments receive them as well. So there might be a reasonable accommodation request to allow a group home for individuals with disabilities to be able to live independently in the community, even if that would not be typically part of their zoning for that area. So that could be another example of a reasonable accommodation. So we're going to talk through the process generally of reasonable accommodation and modification requests. Things you need to know about that before going into more specifics about 3 types of reasonable accommodation requests. So the 3 types of requests we're going to talk about are our assistance animals, hoarding, and parking. So we will get to those in just a minute. I do see that there is a question about a pet policy being discriminatory. Housing providers are able to have pet policies. They could certainly say that there are no pets allowed in their facility, and that is absolutely fine, but they are required to be able to make a reasonable accommodation to allow for assistance animals, as we'll get into in just a little bit. And I do see another question in the chat. If there's a tenant on a Section 8 program, and if they require grab bars in the showers, in the shower, are you required to provide them? If they would provide sufficient documentation about their need for grab bars in the showers, if that's a non-observable disability, yes, you would be required to go ahead and provide those, but we'll get into that in just a little bit. So going into handling a reasonable accommodation request, I want to note that this request can be made at any point in the tenancy. It can be when someone's inquiring about a unit. It can be when they're signing the lease, when they're moving in, 15 years after they've been living in the unit, or even right before they move out. This is because people's disability-related needs can change over time, and something that they don't need right now, they might need in the future. You never know when a chronic condition might change, or if someone has an accident. There's lots of reasons for a change in need. So it's important that housing providers do consider these requests as they are made. We recommend that tenants make requests in writing, so that way there's clarity for for records for both the tenant and the housing provider, but verbal requests are also equally legitimate. So requests can be made in writing or verbally, and both must be considered. The request does need to be reasonable and necessary for the resident to use and enjoy the property. And the housing provider has the responsibility to treat residents making these requests fairly and to respond back in a timely manner. All right. So when a housing provider is presented with a reasonable accommodation request, they should seek to establish two criteria. Does the person who's seeking the accommodation fall under the protected class of disability? And do they have a disability-related need for that accommodation? So if they are able to establish both of these factors, that the individual has protections under the class of disability, and they have a disability-related need for the accommodation, how should the housing provider respond? Should they say yes or no? Feel free to pop that in the chat. What do you think? Should they grant the request or should they deny that request? Yes, grant it. Thank you. They should grant that request. Now, there might be some documentation that's needed before they're able to grant that request. And a housing provider can ask for proof of need, but only if the disability is not observable. So if someone has a very clear and visible disability-related need and they make the request, so they come in a wheelchair and they're requesting a ramp, it's observable, right? You know that they've got a mobility condition and they've got a need for a ramp. So there wouldn't be any further documentation needed. But if they have a non-observable disability, they can ask for more documentation about their disability-related need. It does not have to come from a primary care doctor. It can come from any licensed medical provider that is knowledgeable about their condition. So it can be from a nurse that provides care. It can be from a therapist, a psychologist, an optometrist, but that provider does need to have reasonable knowledge of that person's condition. There can also be alternative documentation provided to establish disability, and that can include determination of disability from a governmental agency, a receipt of disability benefits or services, as well as eligibility for housing assistance because of a disability. And this is because these governmental agencies have already done the due diligence in establishing proof of disability in order for them to receive this assistance or benefits or services. You can learn more about that in some guidance from HUD that was published in 2020 regarding how housing providers can assess requests for assistance to animals, and that's linked on the slide right there. We often get follow-up questions on what's reasonable, right? But assessment of reasonableness is on a case-by-case basis. Some factors that you should consider include the cost of the accommodation that's requested, the financial resources of the provider, the benefits of the requested accommodation to the person who's making that request, as well as the availability of alternatives to the accommodation that's being requested. There are some situations in which a housing provider can deny a request, and those include if they did request documentation and that documentation wasn't provided. They do not need to grant that request until they've received that documentation. Now, if the specific request would pose a direct threat to the health and safety of others, it could be denied, or if granting that request would cause substantial physical damage to the property. If there would be an undue burden that was placed on the provider, or if it would fundamentally alter the nature of the provider's operations, that could be denied as well. But that denial should not be the end of the conversation. That's when the housing provider should engage in the interactive process. So that just means start a conversation. let's see if there are any reasonable alternatives that may meet this individual's disability-related housing needs. So if that specific request can't be granted, maybe there is something else that would be able to help this individual continue to be able to live in their unit. Some things that you should keep in mind is that this discussion must take place in a timely manner. There should not be long delays in between communication. It can take some negotiation and conversation in order to determine an effective resolution. And we do recommend that housing providers fully document this conversation, save it in their records, as well as send it to the tenants as well. So that way there's clear records on what the conversation was and what was decided. As you're engaging in conversation, it's important that that a housing provider not ask several things. So they should not be asking about the nature or the severity of a disability. They should not ask questions that would lead the tenant to disclose privileged medical information. They should not ask to see the tenant's medical records or ask if the tenant is able to live independently. So a tenant has the right to medical privacy, and the housing provider does not need to know those specifics. So they should not ask those questions as part of the interactive process or as they're responding to a reasonable accommodation request. So that brings us to the end of our general process discussion. If you have any questions about any of that content, please feel free to put that in the chat. But we are going to go on to talk about some more specifics around service and support animals. So let's start off talking about some terminology, since we use some of these terms interchangeably, and I know that can be confusing. So we're going to start off talking about assistance animals. So this is a broad umbrella term. So this includes both service animals as well as emotional support animals, which are also sometimes referred to as support animals. So both service animals and emotional support animals, ESAs, are covered under fair housing protections. Now, there's a third category of animals, which are called therapy animals. They're specifically trained for use in therapeutic settings, such as hospitals and nursing homes, and they are not covered by fair housing protections. Going a little bit deeper into service animals, a service animal is generally trained to perform a specific task. They generally support someone who has a physical disability, although it may or may not be obvious. And typically, in most situations, a service animal will be a dog. So examples of what they can do or provide for an individual include pulling a wheelchair, providing mobility support, guiding individuals with vision impairment, or detecting and alerting individuals of oncoming seizures. There are many other things that dogs can be trained to do. It's pretty incredible, but that's a list of examples of what they can do. Next, we're going to talk about support animals, or ESAs. So support animals are less likely to have any type of special or formal training, but they still provide a valuable function for an individual with a disability. They can be any type of common household animal, so a dog, a cat, a bird, a hamster, animals that would be commonly held as a pet. Examples of what they can do include alleviating an individual's anxiety, reducing their depression, keeping an individual calm, or making them feel safe. So they're often helping a person to be able to manage a condition that we can't see and is not obvious. Now, a few years ago, the Pennsylvania legislature passed the Assistance and Service Animal Integrity Act. This was in response to concerns about individuals falsely representing that their pet or other type of animal was a support animal when they were not actually a support animal. So this is a state law that was passed in 2018 that does make it unlawful to falsely represent that an animal is an assistance or a service animal. I want to take a moment to talk about licensure and certification. So under our fair housing laws, there is no certification or licensure that's required to establish that an animal is a service or support animal. It's not necessary. An individual does not need any type of vests or special tags. There are many websites online that will try to make people believe that they need to have these extra things, and they are not necessary. Sometimes individuals will purchase a vest or some type of tag when they're taking them out in public to let folks know that these are working service animals and they shouldn't be disturbed. But I do want to emphasize that these are not necessary in housing. And I also want to address online letter providers. So there can be confusion for both tenants and housing providers about how to get that appropriate documentation. And there are websites that do sell letters for a fee. I want to read directly from HUD's guidance on this that was published in 2020, since I think the language is pretty clear. And it states that some websites sell certificates, registrations, and licensing documents for assistance animals to anyone who answers certain questions or participates in a short interview and pays a fee. In HUD's experience, such documentation from the internet is not by itself sufficient to reliably establish that an individual has a non-observable disability or disability-related need for an assistance animal. By contrast, many legitimate, licensed healthcare professionals deliver services remotely, including over the internet. One reliable form of documentation is a note from a person's healthcare professional that confirms a person's disability and/or need for an animal when the provider has personal knowledge of that individual. So it can be complicated, right? A lot of folks receive telehealth these days since that's much more widely available, especially since the start of the pandemic. So simply receiving a letter that has out-of-state licensure is not necessarily a reason that a letter is false. But if a provider does believe that someone has simply obtained documentation from the internet through one of these websites that would provide a letter to anyone who does that short interview and does a fee, they can request additional documentation in order to verify that this request is legitimate. Now, a housing provider may require that all individuals with animals follow state and local regulations, such as requiring licensures and vaccinations as applicable, so including both pets and emotional support animals, service animals. They can issue violations if the animal's conduct does violate the rules of the housing provider. And they can hold a tenant responsible if the animal causes physical damage to the housing unit. So the animal is an extension of the individual with the disability. So if the animal is causing damage, the tenant would be responsible to pay for that damage as well. Now, a housing provider cannot put limits on breeds or impose weight limits on assistance animal requests. So even if a property would have these restrictions for pets, they do need to be waived for assistance animals. And a housing provider should be cautious before citing insurance policy cost as an undue burden. That's something that often comes up when I provide trainings to housing providers, that they're worried about increases in costs or losing their coverage. So they must do due diligence in exploring other policies on the market and fully documenting that they are seeking to meet their fair housing obligations with their current provider before they would decline an animal because of insurance policy costs that causes them an undue burden. And then lastly, they may not pass along additional expenses by charging extra fees, rents, or requiring extra security deposits for assistance animals. That brings us to the end of our assistance animals portion of the presentation, and we're going to move on to hoarding. If there are any additional questions about assistance animals, you can feel free to put that in the chat at this point. But we're going to move on in the interest of time. I want to start off with a definition of hoarding disorder. So this is sourced from the DSM-5, and a mental disorder marked by an obsessive need to acquire and failure to use or discard a significant amount of possessions, even if the items are worthless, hazardous, or unsanitary. It's marked by a perceived need to save items as well as distress with discarding them, accumulation of possessions that congest and clutter active living spaces, clinically significant distress or impairment in social, occupational, or other important areas of functioning, and this is not attributable to another mental condition or explained by symptoms of another mental disorder. So when we think back to our original definition of disability, so substantially limiting one or more areas of major life activities, it's pretty clear that that this has a significant impact on someone's daily life. And hoarding can have significant impacts on individuals. So looking at impacts to the person with hoarding disorder, it can lead to conflict with loved ones, health and safety risks in the home, being unable to prepare and store food, being unable to have people visit, risking losing your housing or having your utilities shut off, financial problems, mental health problems, as well as shame, embarrassment, defensiveness, stigma, and trauma. And this information is sourced from the Philadelphia Housing Task Force, Hoarding Task Force. But hoarding also impacts the community. So it can impact the landlord and the neighbors. So the landlord has the responsibility to provide safe housing to the tenant and others that live on the property. So disrepair, maintenance hazards, infestations, and citations can impact others as well. There can be an impact on code enforcement through structural damage, blocked exits, citations, and condemnation. Emergency responders can be impacted by fire hazards in the unit, being unable to get the access for medical personnel to enter the unit when needed. There can be impacts on the health department if there's infestations and other health hazards present. And depending on the situation, senior services, child protective services, or animal protective services may need to get involved. And this is from the Philadelphia Hoarding Task Force as well. I want to offer as a resource the clutter hoarding scale that's put out by the Institute for Challenging Disorganization, which does a lot of resources and technical assistance around this issue. I know that's very small font on the screen there, and you may not be able to read that right now, but that is linked at the bottom of the screen and can be a helpful resource in seeking to identify the extent of the issue and how it's impacting those in the unit and those that need to be involved with helping to address the issue as well. But I don't want to address this from a perspective of the housing provider in terms of what needs to be done to bring the unit into compliance. I want to address this issue from a fair housing perspective, since that is the focus of today. And because individuals with hoarding disorder do qualify as individuals with disabilities under fair housing, they may ask for a reasonable accommodation in order to be able to get their unit in compliance with the housing provider's policies. And that often may look like a request for additional time or to bring in outside providers to be able to assist them. It's the housing provider's responsibility to enforce the lease terms, and it's the resident's responsibility to ask for that help and make that reasonable accommodation request. It's important that the focus is on prioritizing the safety first before the more cosmetic issues. So making sure that you can get into and exit the unit safely, making sure there are not fire hazards and electrical concerns. And I do want to note that if someone does have outside supports that can assist them with addressing this issue, whether that's family supports, others in their social circle, or even professionals, it can be helpful for a housing provider to invite the tenant to include them in on discussions and as they're making a plan to address this issue. It's important to ensure that expectations are clearly defined for both parties, stating what is expected and the outcomes of noncompliance. It's very helpful to communicate in writing, so that way both parties have your records. And it's important to be conscious of individuals' attachments to these items, to use neutral language when we're having these conversations. It's not going to be productive to speak disparagingly about someone's belongings because they are collected because they're important to them. So talking about items and belongings, things, can be more productive in advancing conversations than talking about people's junk and garbage. And I do want to note that these accommodations in this area, they may be long-term. It may take continued conversation, continued interactive process to be able to resolve this. So it's important to keep those communication lines open and to continue to work together to make sure that this is a safe living environment. I want to touch really briefly on parking accommodations. So a property may already have designated handicap parking spaces because of accessibility requirements for the building or the property, but this does not remove the obligation to make reasonable accommodations for a tenant who might need a different parking space or one that's reserved based on their mobility concerns. If a tenant does make a request for a designated handicap parking space and they do provide supporting documentation, the housing provider is required to accommodate, and courts have found that housing providers are responsible for the costs associated with making this accommodation. We're getting to the end, but I do want to acknowledge that sometimes granting reasonable accommodation or modification requests can have an impact on other residents of the property or in the neighborhood. So if another resident would voice disability-related concerns, it's important to work through this with both parties in order to resolve these issues using that interactive process. So an example of this could be a resident who requests an emotional support animal, but then another resident comes forward and discloses that they're allergic to cat dander. That's something that may need to be resolved, depending on the severity of the allergy and the proximity to the animal. If you are having difficulty navigating this situation as a housing provider, I do want to note that PHRC does have a fair housing line, and that's 855-866-5718. Or there are also local fair housing agencies that are funded by HUD throughout Pennsylvania, and they also can be excellent resources in helping you work through this. To close out this discussion, I want to leave you with some best practices. And a housing provider should have an established policy regarding how they handle these requests, documenting everything in writing, limiting the information that they request to what's needed to process that request, and allowing sufficient documentation time for that documentation to be submitted. A housing provider should make sure that they're responding to requests in a timely manner within 10 days at the most, and engaging in interactive dialogue in order to meet the needs of their tenants. All right, we're going to do a real quick review of the complaint process. And that starts by contacting our agency. So to file a complaint, if you believe you've experienced discrimination, you may contact the regional office near you, or you can call our main phone line. We've got the information for all of our regional offices there, as well as our website and our email. You can reach out to us in any of those ways. With the intake process, if a person believes that they've experienced housing discrimination, their first step is to contact with our intake team. They'll be asked to fill out a housing questionnaire to provide the basic information that's needed. So their contact information, what they experienced, and who they're filing against. The intake team, their responsibility is to assess this information to see if this is a situation that we can investigate under state law. So if this complaint is jurisdictional and if it's timely, the intake team will help them finalize their complaint, and the person who's filed against will be notified. And then it transitions into the investigation. So the person who files the complaint, we call them the complainant. They'll be asked to provide information to a neutral investigator who's responsible for investigating if there's a violation of state law. The respondent, who's the person who was filed against, they also will need to provide information as well. The investigator will ask for documents, interview witnesses, and they may choose to hold a fact-finding hearing or seek other ways of obtaining evidence. We do have mediations services at PHRC, and they may also be an option in resolving this complaint, depending on the case and if both parties do agree to those services. The investigator will also explore if it's possible to settle the case before a finding. If that case moves forward to a finding, there are two possible outcomes. So either probable cause, meaning there is sufficient evidence to establish that discrimination did occur, or no probable cause, which means there was not sufficient evidence to establish that discrimination occurred. If there's no probable cause, that's pretty much where the case ends, unless someone would want to file an appeal because they believe there was an issue with the investigation and it was not conducted appropriately. But if probable cause is found, then that case may be conciliated, it may advance to public hearing, or be filed in court. And at this point, the goal for our agency is to seek a remedy for the discrimination that occurred. So at this point, we are no longer neutral. The amount of time that it takes to investigate a case really can vary based on the evidence, the speediness of responses, and other factors. Why would someone file a complaint? What can they achieve through that? Well, it might be that that reasonable accommodation or modification request is made, meeting that person's disability-related needs. Maybe there are changes that are made to the housing provider's lease if there were policies that were violating our laws. Often there's posting of notices to make sure everyone understands their rights, training for respondents, making sure that they understand their responsibilities under our laws. And there are also financial remedies, including reimbursement of fees and out-of-pocket expenses. In housing and commercial properties, complainants may get money for humiliation and embarrassment, and then there may also be civil penalties that are assessed if the case advances to public hearing. You can read about our housing awards. We also post our most recent ones on our website. You can take a look at that as well, but I want to take a minute to highlight our fair housing resources, including our fair housing line, our training programs. This is part of a monthly series, and there are upcoming ones that are listed on our website as well. We've got written materials, as well as a show on PCN called PHRC Speaks. And we also have a white paper looking at housing needs and barriers called The State of Fair Housing in the Commonwealth of Pennsylvania. And we just announced the date for our 2025 Housing Equality Conference, which will be held in Pittsburgh on April 8th at the Wyndham Grand. I would encourage you, if you're able to travel and meet us there, we would love to have you be a part of that day, and we will be announcing more information soon. Our theme this year is Navigating Today's Challenges and Building a Fairer Tomorrow. I do want to note as well that we've got a QR code on this slide. So if you're able to take out your phone and open the camera app and get to the survey that way, that's excellent. My colleague also put a link in the chat as well. This allows us to get some feedback on the quality of our training, and it also will allow you to download a certificate of attendance for today's program as well. So please feel free to check that out as well. I did see there were a couple questions in the chat that I do want to get to. If you have additional questions, please feel free to go ahead and put those in as well. I see there was a question about internet letters coming with an expiration date. If there is an expiration date on the letter, can the provider require that the resident revisit the accommodation and require an updated letter? So if a letter is out of date and that's specified, then a housing provider may have the tenant go ahead and get a new letter to make sure that that the letter reflects that person's current needs. And there's also a question about sufficient time to get documentation from the unit, from the resident. I would look to the HUD's guidance on assistance animal requests. I know they state that 10 days is a reasonable amount of time for a response, so I would start there with the resident, giving them that time to be able to submit that documentation. And if they would state that they would need additional time, because it can take time to get appointments and documentation and go through all that, I would encourage you to work with the resident on that as well. All right, I am looking through the chat to see if there were any additional questions that I did miss. I'm not seeing any at present, but on the screen there, you also have my contact information. You can shoot me an email, and I'm always happy to answer questions that folks have and provide information and resources. I would like to thank you all for joining us for today's program. Yeah.
Wanda has a question. Her hand is
Okay.
up. I don't know if you can view it.
Give me just a moment, Wanda. I am to see if I can enable your mic. Are you able to unmute? Wanda, are you able to speak now? Well, while Wanda is working to get unmuted or to put a question in the chat, I would like to say thank you again to our interpreters as well as to our captioner for providing services at today's program. I would also like to thank my colleague Caroline Eister, who's PHRC's Director of Fair Housing and Commercial Property, for providing technical assistance during today's program. I'm hopeful that we'll be able to get to this last question, but I'd also like to thank everyone who was present at today's discussion and this training and for interacting. Wanda, I'd like to give one last opportunity. Are you able to put your question in the chat or to come off mute? All right, I don't think we are going to overcome this technical issue today, but I do see a question in the chat, and we will be sending everyone the slides as well as the recording to this presentation for future learning.
Yeah, your mic is allowed. I'm not sure. If she's unable to unmute herself.
All right, well, we will reach out to you, Wanda, following the presentation to see if we can get your question answered. Thank you so much, everyone, and I hope you have a great rest of your day. Take care.